Thank you for attending tonight's seminar on estate planning. We're so glad that we've had actually over 100 signups, and this is probably our most popular online seminar to date. Just as a brief introduction, so my name is Jean Joe. I'm the broker and owner of Parison Real Estate. Parison was founded in 2016, and the word Parison comes from the Greek word for abundance and overflow. And our vision, our company's vision, is to really serve our clients so that they can thrive and experience abundance in their real estate lives. These seminars we've been doing ever since we started the company, and in person. We used to be in person, and then we went on to Zoom this year for obvious reasons. But it's really an outflow of the vision that we have to really be able to share, to provide value, to really seek to help educate our community and our clients, and even fellow agents we invite to these seminars because we think it really is important for everyone to be as informed as possible in making all of their decisions. A brief outline for tonight, so introduction, which I'm doing. Then we'll just launch straight into estate planning basics and COVID-19 considerations. This will be about half an hour, and then we'll go into Proposition 19, specifically to cover the impact on inherited properties, because to just keep in line with the whole theme of estate planning. Estate planning basics and COVID-19 considerations will be presented by Jubilee Menzies, if I'm pronouncing that right. And she's an attorney who specializes in estate planning and elder consultations. So I'll let her introduce herself a little bit further, but a lot of things that as I've learned more about her, that I really love the way that she views her clients and really views herself as an advocate for others. And then the Proposition 19 portion, I'll do an introduction, but we have with us today Joe Dalli, who is a CPA, and he is an incredible resource, so knowledgeable. I know other agents, other real estate agents and brokers who've been in the area who refer to him because he is such a trusted resource. So I'm so excited to have both of them with us today. I hope that they can have some time to introduce themselves. And then we'll go into announcements, just a couple announcements, and then an additional time for question and answers. So we're going to go ahead and launch right into estate planning basics and COVID-19 considerations. So I'm going to hand this over to Jubilee.
Good evening. Thank you very much to Jean for having me. As she said, my name is Jubilee Menzies, and I am an estate planning attorney. I've been practicing in this area for about the past 5 years, coupled with elder law as well. And one thing that I've noticed during this time is there are actually quite a few misconceptions, both about what is covered by estate planning, but also what exactly is an estate plan. So I notice this because I hear things like, I don't own a home, so I really don't need an estate plan. I don't have an estate. Or I'm married, but I don't have any children, so if I die, everything I own will just go to my spouse. We're all set. Another thing I run into a lot is people who say, well, I'm young and healthy, and I know it's a good idea, but I just don't need it now. Like, I'll deal with it when I come to that point in my life where I need it. And the other one is kind of the converse of that, like, well, I have parents who are aging, and I'm in line to inherit the family home, so I really don't need to do anything until I know what's going to be in my own estate. And I wanted to just take a couple of minutes to go over this bigger concept of what exactly are we talking about then, because there's a lot of ideas there that are showing that you're kind of missing something. So when we're talking about estate planning and a specific plan, yes, we're talking about what happens to your stuff when you die. And that includes any houses or any, rental properties or a vacation home. But we're also talking about a lot more than that. We're talking about things like what happens to your minor children, and not just who do they live with and who's going to take care of them, but also what happens to any money that you might leave behind for those kids. So if you were to have minor children and pass away, if one parent dies, usually the second biological parent is the person who would take full custody of the child. But we run into some concerns here, particularly with divorced families and new blended families, where you might have a situation like a second marriage for both spouses and each has children from a prior marriage. And they may even have a new child of their own. So we end up with this family with children living together, and they actually come from 3 different sets of parents. So if one of those biological parents in that new family were to die, their child would presumably first be in line to go to the other biological parent who they don't currently live with. And sometimes we have shared custody situations where that's not a concern, and that might be what you would want. But the second piece to this is who's going to manage any money that you leave behind? And so you might have a situation where it may be an ex-spouse and the parent to the child who you would want them to live with that person, but you wouldn't want that person to manage any money you left behind. Marriages often break down over finances, and sometimes, that's the very issue that you don't want coming back up in terms of with your child. The other thing is you might be choosing someone in your family that you're thinking, okay, well, this would make a great person who would care for my kids, and we have similar values. And I think that they would be a great person to take them into their home, but I really am not so sure about their own personal finances. And sometimes people are surprised to find out you can actually have 2 separate issues here in different people. So one is the guardian of the person, and the other is the guardian of the estate. And you can make that decision if you plan in advance. If you don't plan in advance, then with the money issue, you have funds would go into a trust for a minor in California, but once they turn 18 with no advanced planning, then that's it. The money that they were set to inherit is theirs outright. And you might not want your 18-year-old senior in high school to suddenly inherit a windfall, or your 19-year-old freshman in college to go ahead and take the money from your investment property and buy themselves a condo in Cabo for spring break for them and their friends. You can make advanced plans to prohibit that type of thing while also carving out specific large purchases and large expenditures in a trust. So you could say, okay, my young adult child could spend money on a primary residence, but not on any other kind of property in their teens and early 20s. You can say, okay, they can't have all this money outright, but they could use whatever they need. The trustee could earmark money for a medical expense or for their education, so they can get their college paid for from money that you have left behind, but they can't just go out and buy the next latest and greatest this or that. So moving on a little bit from what happens to my children, another major issue that comes up in estate planning in general is health crisis planning. And the next bullet point also, who's going to make decisions for you while you're alive, but unable to make those decisions for yourself? And the health crisis planning piece, we'll talk about in a little bit more detail later on when we hit some of the COVID-19 implications, particularly relevant to this year. But as we're talking about this topic, this kind of planning gives you the opportunity not just to decide who's going to make decisions for me, but to provide guidance and to say, okay, these are the things that I am concerned about, and these are the wishes that I would have around, both health and finances. And then you also earmark which person you want to carry out your own decisions and kind of provide the responses to questions that come up in those critical times based on what they know that you wanted. So it really gives you a lot more opportunity to have control in some of the most difficult times you might face in your life. And then lastly on this list, we have special needs planning that could be for you or a loved one. And this generally breaks down into 2 different types of special needs trusts. One being a first party or self-settled special needs trust, where you are the person who is disabled. And that often comes into play with a person who got injured on the job and they're unable to work now. They're categorically disabled under the law, but they might have a settlement from a lawsuit from whatever that work accident was. And so you find that people are in the situation where they actually need some sort of government assistance, usually with medical expenses, and that would be through Medicaid. And in California, that's Medi-Cal. And so you might have someone who they need that Medicaid, but Medicaid is based on need. And so if you have this settlement, then that's going to disqualify you for Medicaid. But if you set up one of these special needs trusts, you can kind of you can have a little bit of the best of both worlds. And so you could still be eligible for Medicaid and still receiving the medical benefits that you need, but also you can use whatever money was yours that you put into that trust to supplement what you have in your life in general. You couldn't use it to totally supplant and take the place of the same type of thing that you're receiving public benefits for, but you can add to and really improve the quality of life that you would otherwise have, and not find yourself in this situation where you're in need, but there's this short amount of time potentially that money you have or money you got from a settlement would make a difference, and then it's going to be gone. It can get very complicated. One thing to note about this type of special needs trust is that you do have to write into it a Medicaid payback provision. And so if it were the case that you had this trust and you were also receiving benefits, and then you were to pass away and there was still money in that trust, then Medicaid would have the opportunity to seek reimbursement up to whatever expenses they had paid out on your behalf. And now, let's say you have, Medicaid paid out $1 million on your behalf over your lifetime that you were receiving these benefits, and there's only $600,000 in your trust. So Medicaid can seek reimbursement and get reimbursed that $600,000. It doesn't mean that then now your family's going to have this $400,000 bill that somehow creates a debt. That's not how it works. And conversely, let's say, Medicaid paid out the $600,000, but your trust actually has $1 million still in it when you die. And so Medicaid could seek that $600,000 reimbursement. And then what's left over would be distributed according to whatever plan you had made and to whatever beneficiaries you had designated. And so that's what kind of the basics of a special needs trust that's for the first party that you did for yourself. The other kind is a third party special needs trust. And with these, it's just a follow the money rule. We're looking to who put the money in. And so a third party special needs trust is where someone puts money into a trust for the benefit of another person. And this often happens if you have a disabled child, or you have a disabled relative or loved one, whoever it is that you would like to name as a beneficiary. Similarly, like I mentioned before, the real thing that comes up here often is the public benefits. So if you put money into a special needs trust, it's not going to knock that person out of eligibility for benefits that they might need. I had one situation where I had a client that this didn't happen, and it was a really difficult thing because what had happened was a mother had left her her assets to her two children. Well, her adult son was blind, and he was, worked very little and was considered disabled by law. And he lived in housing for persons with disabilities, but it was low income. So he qualified based on his limited funds. But once he got this inheritance, he no longer qualified for those benefits. It wasn't that, he could just move into another apartment in the building. He had to move out of the building altogether. And what was particularly difficult with his disability was he had been there for more than a decade and knew how many steps does it take to get from the front door to the elevator? How long does it take me to ride up to my floor? How many steps, how many doorways down the hallway until I get to my own apartment? And this, on one hand, you would think coming into an inheritance would be helpful, but it was very, very disruptive and hard on not only him, but his family, who then had to come in and look for, okay, well, we need to find new housing, but how long is the inheritance going to last, and whatnot. So, you know, there are ways to handle that in other ways once you're kind of in that crisis situation trying to resolve it. But obviously the best option here is to plan in advance. And if you have a disabled person that you're considering leaving money to, then you specifically create a special needs trust for them, and you earmark those funds so that they won't have those life disruptions like I'm describing. So now we talk about, okay, so when you say estate plan, what are the pieces then? To just break down some of the basics and talk about the documents that we're putting together to make these decisions and help you get your plan together. It usually will include a revocable trust, which revocable meaning that it can be revoked, you can change it. Whoever set up this trust, you can make changes, or you can completely revoke the thing in its entirety. There's going to be a will that complements that trust. It may very well be a pour over will, so that whatever things you have sort of on the side, they pour into that trust, which is where you are naming your beneficiaries and explaining what exactly it is you want to have happen with your things. And that's also the place where you can create subtrusts, whether it's for, you know, a specific charity that's important to you, or people have actually really gotten into making pet trusts. You set aside a little money for your favorite pet, that whoever, you know, has agreed to take care of this pet has a little bit of something to, you know, do right by you and your little fur baby. We're also talking about doing your advanced healthcare directive, and, you know, optionally, if you'd like, a HIPAA waiver with it, where you make those decisions about what you would like for medical care, or how you would like to be treated in the event that you are unable to make decisions for yourself. Similarly, your durable power of attorney, that's where you're setting up, okay, who's going to help me making financial decisions based on, you know, the guidance that I've provided in the event that I am still alive and I can't make those decisions myself. We are also talking about any real property that you have, retitling the deed so that it is in the trust, and any optional documents that often people will have a kind of end of life burial or cremation plan, and you can say there specifically, you know, I would love to have this hymn sung at my memorial service, or, you know, I've really taken to the green burial idea and here's my specific instructions. You can also talk about decisions you have already made and anything you've already potentially put in place in advance, like a cemetery plot you've already purchased or whatnot. And I know on this part, Joe, you had mentioned about, well, actually, I'll do that in a minute. I'm just going to keep rolling through this. So next we talk about, okay, so we're talking about, now I have a trust set up, but what does that mean in relation to probate? I hear a lot about probate. And just kind of a very basic breakdown between the two. With probate, if your assets are not in a trust and they haven't been earmarked as you've specified, then they're going to go through probate, anything over about $150,000 now. And that is a public process. That's in the courts. That's public record. And it's also a very lengthy process. And the most important thing to most people is that it's a very costly process. And so if we can just jump ahead here to the next slide, the cost of probate is set out by statute. And this is just simply fees for attorneys' fees or executors, administrators. And this is how the breakdown is. It's 4% of the first $100,000 of the estate, 3% of the next $100,000, 2% of the next $800,000, 1% of the next $9 million from there, and then 0.5% of the next $15 million. So how that all breaks out is like this. You know, if we start at the bottom and we have a $100,000 estate that does get probated, it would be a $4,000 attorney's fees. If we jump to a $1 million estate, that's $23,000 in attorney's fees. If you have a $5 million estate, we're talking about $63,000 in attorney's fees. And then a $20 million estate with multiple properties, we're talking about, you know, over $150,000. So if we can jump back a couple slides, we contrast that to the difference is with a trust, you do this planning upfront and you pay the cost upfront. And so you are paying an attorney to help you set this up. And usually that runs, depending on the complexity, anywhere from say $3,000 to $8,000 as a range. This is a private process. This isn't something that's going to be open record and that people can know about and every busybody finds out every last decision you made. It's also, as I just mentioned, you're paying the cost upfront. You're not incurring those other fees. And a huge thing that you do is you avoid a wide variety of taxes and you can do better tax planning. And also quicker administration is one of the major benefits. So if we jump back up to here, we're kind of circling around these issues. Well, why do I need an estate plan at any stage in my life, whether I'm young and don't have much, or I have kids but I'm waiting to have more kids, or all of these things. The main reasons are it gives you choice over what you want to happen, not only with your things after you die, but with your own life while you're still alive and while you are potentially incapacitated. Or sometimes people, they still have the capacity, but they've gotten to a point in life where, let's say, they're just tired and they don't want to manage their own money anymore. And that can be a time where, the person that they have named as their agent is making decisions for them. And that's part of the choice and the control that comes into play here. And also just simply the privacy. The second major reason is to avoid probate altogether and to save money. And the last reason that's really much more of kind of a human reason is that when you take the responsibility of doing the planning in advance and thinking through those hard questions and making those hard decisions, you're really giving a final gift to your loved ones when you do pass on, because at that point they're experiencing the grief of having lost someone, but they're not also all tied up in, okay, well, what do we do with this thing? Or I remember my parents had this, vacation condo in Palm Springs, but I haven't been there since I was a kid. And, they're not scurrying around trying to track down what things you may have had or this account or that last thing. And they're also not squabbling over, mom's diamond ring that all the daughters wanted or all the sons wanted, this or that. And, Joe, this is something that you had talked about, yeah. Particularly with properties and with numerous beneficiaries and whatnot. I don't know if you want to jump in here.
Sure.
To that.
Well, a couple of things. First of all, you mentioned that, if you have a trust, but, and everything is written in there exactly where you want everything to go, it's nice. What if somebody has a well-written will, but no trust, that has everything all written out as to who is supposed to get what and where? Does that escape you from the probate process?
You still end up in probate. Your assets still end up in probate there.
Sure. So the idea is, if you have a well-written will but don't have a trust, you're really, you're not quite at square one, but you're very close. The second thing is that your list of fees, you're talking about attorney fees, are those, what about executor fees? Are those also the standards for executor fees? So you may have double that amount?
Yeah. And that's, and there are other administrative costs associated with probate as well. So that's not your maximum. That's kind of, that's one category.
Sure, it's your minimum. Yeah, so what we were talking about before was that I've known people who did their own trust online or whatever it is, and that was the end of it. And they found out once the first person passed away that they had to put all their properties in the trust. In other words, it's great to have a trust, but if it isn't funded, then it does nothing, and they were back at probate. It's almost like they wasted their time. The second thing is like, I'm right now going through a refinance of my house, and I'm sure most of you are probably, a lot of you are probably doing the same thing because these interest rates are great. Well, what happens is when you go to sign your papers at the escrow company, the first thing they do is they take the property out of your living trust in order to fund the loan, because they don't want to fund a loan in a trust. So a lot of times the title company forgets to put the property back into the trust. So you've refinanced, you're going along, you think everything is fine, and the property is no longer in the trust, and you potentially have a probate situation. So you got to be careful when you're refinancing to make sure that the title company goes back and puts it into the trust.
Yeah, thank you for that. Thank you for those. So, which brings us to our next question. Okay, so great, you've convinced me I need to do this planning now, but do I really need a lawyer? Can't I just print a will that I found online? Can't I just write my own trust? And the answer is yes, and there's definitely a place for these services to some degree, and you can get something that you found online and have it be effective, but you're really looking at the type of situation you encounter anytime you're hiring a service professional, right? You're not just paying for the document. If you want just the document, then that can be the place to go. But really what you're doing is you're trying to find someone who can help you comprehensively look at your situation, ask you the questions that you don't even know you need to ask, and kind of ferret out the whole gambit of what it is you're dealing with, and get all the pieces in place so that you're not making these mistakes like, well, I have a trust, I did it myself, but I never funded it, so it doesn't function. Or, I own property and I'm a joint tenant and I put my share in the trust. Well, now that's not how that works. If you're a joint tenant and you try to, also layer trust over it, you're going to break the joint tenancy and you're going to create other problems that you didn't realize you were creating. And so it's one of those things. The more complex your situation, the more numerous the people involved you have, or multiple persons owning property, or you have multiple beneficiaries you're passing down to the next generation, and there's a bunch, that's the greater complexity you're going to face. And it's just one of those things that you're really paying for what you get, and you're looking for more than just documents. You're looking for the service to help you and counsel you and guide you through the process. There we go. And so in this, one of the questions I raised early on is like, well, I'm in the position where I'm set to inherit soon, and I don't really think that I need to do my planning now because I don't know what I'm going to have. But the way these things work is you set up a trust now that meets your needs, but it also kind of uses language to provide for future changes and to give you the opportunity to adjust a little bit without reworking the whole entire thing. One example would be, maybe you're a young couple and you just had your first child and you're thinking, okay, well, we need to set something up, but we plan to have more children. Well, you can write your trust now and you can name that child, but you can also provide for and any future children. And so with that, we're looking at something where you can make it so it's going to be flexible, but you do also definitely want to go from there and know when it's time to go ahead and make changes. So you do need to later name those kids. If you happen to pass away in between those stages, your trust would still work for you, but you don't want to just leave it like that for 20 years. So a couple quick things, okay, well, when do I need to look for a checkup? If you have those family changes. Sometimes you have a charity you've been donating to and you no longer want to. And then jumping down here, Joe, I'd love to have you jump in. One of the big things is you want to make changes when there's been new tax laws that are going to implicate the decisions you've already made. And, we have this estate tax issue that we're kind of in the middle of with the exemption limit right now this year, and also the Secure Act of 2020, if you can speak to those.
Sure. So yeah, and we'll get to that in the Prop 19 part, but yeah, currently we have an $11.7 million estate exemption per person, and it went up from $5,800,000 from the law that President Trump had passed back in late 2017. So that's slated to sunset. That means it goes away at the end of 2025. We had it going up and down over the last 20 years, and people would, make adjustments to their estate plans as that was happening in order to just be up to date, to reduce any estate tax issues that might come up, or obviously reduce estate taxes. So those are all, whenever there's a major law change, there's going to be impacts to the estate picture as it is, sometimes very subtle, sometimes like in 2012 and in 2016, momentous. So yeah, it's always good when there's an estate, a change to the state laws to go ahead and at least take a look.
Mm-hmm. Exactly. So just to take these last couple minutes, one thing we're experiencing this year is a huge surge in people who are really needing to take a look at health crisis planning that they perhaps hadn't previously considered, or they're realizing they really need to make changes. So just 3 quick ideas to think about when we're considering this. The first is advanced healthcare directive decisions. And so you may have selected an advanced healthcare directive, you already have one in place, and you're saying, well, you have that thinking in mind that I don't want to live in a vegetative state. And so I told my loved one, like, just pull the plug. And you're thinking, I don't want extraordinary measures. But we're living through a pandemic where the extraordinary measures, a lot of people are being put on ventilators. And that's something that might be thought of as an extraordinary measure normally. And right now it's how people are getting through. And so you might rethink, okay, what actually are the parameters that I can live with given what we know about this particular crisis? So an advanced healthcare directive with more specifics is something to keep in mind. The second thing isn't necessarily an estate planning document, and it's not a legal document, but just simply having some sort of family plan, some sort of family quarantine plan. If you have small children and one of the parents contracts COVID, do you want the kids to stay in the home? Do you have a family member you can have them go and stay with during this time? Do you need emergency care for your kids, or, for your perhaps elderly parents who live with you, or whatever it is for persons who require that kind of extra care. And then also, similar to when we talk about, earthquake preparedness and whatnot, what is your supply plan? Make sure you have supplies. And the last thing to consider in light of COVID-19 is successor agents. You may already have a plan in place, but you may have named agents who are themselves in a high-risk category. And maybe those aren't the people that you want during this critical time to have to make those extra decisions for you. And so those are just a couple of things to keep in mind as well. And with that, I'll turn it back over to Jean.
Okay, well, thank you very much, Jubilee. That's very a lot of information, and I'm sorry I kind of ended up rushing her along after a while, but a lot of important information. I hope it's given everyone some food for thought, especially with the extraordinary circumstances we're in right now. I'm gonna go ahead and launch into Prop 19 because we're already kind of running low on time. So I'm gonna just start out with a quick overview of Prop 19, and I'm actually going to really skim it down because I want to make sure that we get to more of the impacts of Prop 19 in terms of estate planning. So just as a brief overview, as many of you know, Prop 13, which was enacted in 1978, decreased the property taxes to a maximum of 1% of the 1976 assessed value, and then restricted annual increases of assessed value to an inflation factor not more than 2%. So you can only increase the assessed value of a property no more than 2% every year, and then prohibited the reassessment so that it would not reassess unless there's a change of ownership or completion of a new construction. And then there's Prop 60 and 90, which I won't go into, which subsequently made provisions for keeping this property tax base for homeowners 55 years and older. Prop 19, the main piece of it is what's called portability, which is the ability for eligible homeowners to be able to keep their property tax base and when they sell their home and move to another area. So Prop 60 and 90, if you look at the chart for current law, actually allows for the change if an owner an eligible homeowner, again, 55 years and above. Now, if you're also permanently disabled and or a victim of natural disaster, to be able to sell your home and then purchase either in the same county or in a receiving county, what they call, it's only 10 in the state, then you can keep your property tax base. And there are some different calculations in terms of what could be done. And then that has now changed so that you can actually use this anywhere in California, anywhere in the state. Previously, there were some limitations in terms of how much you could buy your new home for. It was limited by a percentage, and it's on the chart here, which I won't go into, in terms of now you can actually purchase, if you purchase at or lower than your existing home, if you purchase a new home at or less expensive, equal to or less expensive than your existing home is sold for, then you can keep your property tax base. Now you can actually even sell above it, buy a more expensive home, and then that would just be prorated. You would have an additional prorated portion. Previously, you can only do this once. Now it's allowed 3 times, and this is going to take effect April 1st. I'm doing a very quick job of this. We actually did a seminar that is posted on our YouTube channel, and so I'll refer you to that. What I'd like to go to is to really talk about the inheritance piece, which is the second major part of this. To go into that, some background, Prop 58 and Prop 193, which were enacted in 86 and 96, basically allowed for transfers from parents to children, or from parents to children, to not be considered a purchase. So it would not trigger a reassessment for your property taxes. And for a transfer of a principal residence, your family home, there would be no reassessment done. And then the first million of any other property would be kind of harbored from that, from the reassessment. So that's how it was due to Prop 58. And Prop 193 actually expanded that to allow for transfers between grandparents and grandchildren if the children of the grandchildren were deceased. So that's the existing law. What Prop 19 did, and I'm going to slow down a little bit now. So you see the current law, Prop 19 applies to principal residence only, which is the same. And then what would happen is that for inherited property, again, for a principal residence, you would have no value change. And then you would have, for any other real property, as I mentioned, the first $1 million would be factored in. And then here are some dates. For Prop 19, if you look on the right-hand side, basically what would happen is that if you have a principal residence, for the principal residence of the, there would be a reassessment, but you would have a kind of an exemption or an exclusion of the first $1 million. So, and we'll give you an example of this just to make it more clear, but that's for a principal residence. And for any other property, any other investment property, it will be now reassessed at the market value. So that's a major change, whereas before it used to have the $1 million exemption. In order to be qualified as a principal residence, for then the heir would need to actually move in within 1 year of transfer. And then this is actually going to take effect February 16th, as opposed to the other portion of Prop 19, which takes effect on April 1st. I know I'm going through this really quickly, so I'm going to actually hand it over to Joe now, who is going to be our tax expert, who's going to go through an example to make it more clear for you.
Well, Jean, you're doing such a great job.
Take it away, Joe.
All right. So thank you so much to everybody. Thanks for having and coming along tonight to visit with us and talk about some things. Yeah, so Prop 19 is one of those momentous items, propositions that pass that people kind of scratch their heads on now that we kind of know what's in it. But let's look at an example to kind of give you what's going on here. Let's just say that, you know, many years ago, a couple bought 2 homes right next door to each other, and they were each bought for $100,000 or $200,000, and so they have a $200,000 cost basis. That's how much they paid for it, and they have property tax. The assessed value then would be the $200,000. Okay, actually $100,000 each in there because they get $200,000 total. So each property's $100,000 assessment of assessed value of $100,000, property tax of around there. So as as a couple of properties, you got $2,200 per year in assessment in terms of property taxes. Now let's just say that each property is now worth $1.8 million, and this happens a lot in California, to where you buy something for 100, it's worth 1.8. Okay, so that's just the backdrop to this. Let's go to the next slide. Okay, so existing law says that, and then, you know, if a person passed away, existing laws would say, a law would say that both of these properties would pass to the heirs with no problem. Basically, the principal residence obviously passes to the other spouse and then to the heirs, because you're allowed to transfer a principal residence. The second property, the investment property, passes to the heirs because the assessed value is less than $1 million. So nothing happens. Now, so under Prop 19 now, we've got some different rules. Let's take the principal residence. The principal residence, let's just say that one of the children or the child of this couple wants to move into the family's home. So they can do so as long as they, you know, let them know within a year. Now what happens, you got two things going on here. You got, the first one is the property taxes. The second one has to do with cost basis. Whenever somebody passes away, under current law, and I got to say under current law because we'll talk later about whether that's changing, all properties get stepped up to the date of death value for income tax purposes. So on this principal residence, this child who now will live in the property will receive this property at a $1.8 million cost basis, for stepped up basis, for income tax purposes, for capital gain purposes. So if they sold it the next day, there would be no gain or loss, which is great. But for property tax purposes, the new law allows for a $1 million exemption, so to speak. So that if the property's worth is $1.8 million, you subtract the million from there, their new property tax base is now $800,000. So their property tax on this property goes from about, you know, $2,200, or I should say $1,100, now is going to be about $8,800, a tremendous difference. Now, even more dramatic on the other property, on their investment property next door. So yes, whoever the heirs are will receive this property at the $1.8 million income tax base because they get a step up in basis. But under the new law, Prop 19, they will also get a new step up in property tax base to, again, the $1.8 million. And that's computed to be about $19,800. So if they choose to keep this property and continue to rent it out, their property taxes has gone up from almost nothing to $19,800, and they're going to have to live with that if in fact they want to keep this property and continue to own it through the years. Next slide, please. Okay, so let's go back and again, let's talk about the step up in basis. So the step up in basis says when a person dies, all their property, all their assets, it could be stocks and bonds, whatever, they get revalued at the date of death value. And so now we have, you know, the situation where in the situation we just had, let's go back a slide, please. So let's go and down to the investment property. So this is kind of what's going on here. If let's just say that this family had thought a little bit ahead, and I'm not saying this is a perfect situation, but they thought ahead as soon as Prop 19 passed, and they said, oh, we are going to gift the property to our daughter so that she can keep this very low tax base. So they ran to their attorney and they gifted the property to their kid, and they lived another 10 years, but now the kid owns it. But the kid, their child gets their adult child probably gets this property, gets a low tax base, and then the parent dies. So now that the child has a situation where they have a really low tax base, right? But they're sitting on a time bomb of about a $1.7 million capital gain. And that's going to probably translate in today's rules of about $600,000. So what the parent has saved the child in property taxes, namely probably $17,000, $18,000 a year, they have cost this child potentially in capital gain taxes of over $600,000. So it would, so the child probably in their lifetime couldn't keep the house long enough to save that much in property tax. And what they've done is they've really kept this kid from wanting to probably sell this property because the capital gain would have been so huge. So that's a great example of the interplay between gifting the property early to kids and giving them the low property tax base versus taking that property and just giving to the child at the time that they pass away and letting that heir decide for themselves, what's the best thing for me? Can I live with paying $19,000 in property tax because I just got a $1.8 million property for free from my parents? I inherited it and I'm grateful for it. Or, or do I just, I can't live with this $19,000 property tax. I could do something better with the money. I'm just going to sell this property that I just inherited. Guess what? I have zero capital gain. In fact, I have a huge loss because of the closing costs. I have zero capital gain. I can go and reinvest in something else or just diversify into other assets. So I hope that kind of explains to you the warring factions, so to speak, that you have to think about when you're thinking about just gifting properties to kids. I own real estate and I have 4 kids and I have no intention of gifting anything to my kids because of Prop 19. That's just not going to move me that much. Okay, so we ask these questions, what do we do here? Since the property, do I give the property to the kids now? Do I give it to later? I think that example kind of shows what to do. Okay, so there's other questions to ask. And so when you ask these questions, you kind of get a better sense for what you're probably going to want to do, or at least consider doing. So the family home, if you have one child, that's kind of easy. You make the same kind of analysis that we just did. Do you want to give the property to the child now or later? If you give it to them later, yes, the property tax base will go up, but so will the cost basis, so that their capital gain will be eliminated until some future year. So on a family home, that's easy. But what if you have 3 kids? And if one kid, see, we're starting to get questions that we don't know the answers to. If you have 3 kids and one of them wants to live in it, but the other kids own 2/3 of the property, if the parents don't have other assets in the estate in order to give those other children those assets and leave the house for the one child who wants to actually move into it, what happens? If 2/3 of the house is owned by the other 2 siblings and the one child who wants to live in it buys it from the other 2 siblings, I can tell you that the propositions that Jean was talking about do not relate to siblings. They only relate to parents and children, not to brothers and sisters. So if they're in a situation where they want to keep the property and they buy it from the other 2/3 from the other 2 children, guess what? They're going to be completely reassessed on those 2/3, and it basically destroys the whole plan. That's why estate planning is important. It has nothing to do with the document. It has to do with the plan. The document is only the end product of all of the planning and all of the thought process that goes into it. Okay, so vacation home. Anything, by the way, anything other than a family home fits into the other category. Vacation homes, rental properties, bare land in Utah, all those things are the second category, which get complete assessment. Well, I guess in Utah it wouldn't. It'd have to be in California, excuse me. But they get complete reassessment at death. Now, let me tell you something interesting about the vacation home. So I have a friend who I talked to a couple days ago, and I'll try and be brief. but they have a beautiful property up in South Lake Tahoe on the California side. And his parents passed away, and the property is now generationally owned by him and his 4 brothers. And they each have a few kids. So, and everybody gets along just fine. So everybody uses the property, they go up there, you know, but my comment to him was, okay, when, you know, you've got 5 people and you've got about 14 kids, what happens when the parents start dying off? Now you've got, you know, 14, 15, 16 owners potentially. You know, things are not going to work as well. For right now, they're fine, but maybe later on it's not going to work as well. But there's really nothing you can do about it. So you don't go ahead and gift parts of the property now, because it just has to happen. And most likely what happens is when the last of the parents dies, either one of the kids is going to buy it from the others and not care about the property tax, or the whole bunch are not going to get along. They're going to want their money, and they're just going to sell the property and split it up and call it a day, which is probably what's going to happen. Income producing property, you know, if you think they're going to be kept generationally, they're going to be, you know, the kids are going to keep it through a couple of generations, that's fine. So if that's the case, we do some planning for that. Okay, if you know the kids are planning to just sell the property at the end and they don't care about keeping it, obviously the thing to do is to do nothing. Because if you do nothing, they inherit the property under current law. They get the step up in basis, they sell the property, it's a done deal. And they don't have to worry about the property taxes, because the property tax base goes up at the same time they're selling once they inherit the property. So it's not an issue. Jean, can I get the next slide, please? Okay. Yeah, so we covered the step up, the rules here regarding that. And I think it's fine. Let me see.
I think that's pretty much okay.
Yeah, okay, so we got that, yeah. I'm just kind of rambling on, but we're having fun. Okay. Okay, let's see. Okay, so we talked about if the kids are going to sell, then if the kids are going to keep it, fine. Then you think about maybe gifting it and all that. But if the kids are going to sell, then don't matter. Just leave it alone. If the kids are going to keep it, then the cost basis, the step up in basis doesn't matter, because the issue is there. They're going to keep the property. They want the low tax base. Maybe we do something now. Okay. And we talked about generationally what happens. So yeah, we're just kind of rambling a little bit, but go ahead. I think next slide. That's great.
Good. I think you mentioned about the reduced estate tax limits. I think that's something.
Yeah. Okay. So we're getting there. We're going to get, okay. So we'll talk about that now. That's fine. And we have one other issue on the next slide relating to when one of the parents passes away. But yeah, so as we talked about before, the present estate tax is $11.7 million a person. It's going to go down to 5.8, I believe, after 2025. And Mr. Biden, if he has his way, he is going to get rid of that extra amount as soon as he can, and that'll go back to $5.8 million. So if your estate is, now I'm not talking about just your rental property, if your entire estate as a single person is greater than, say, $6 million, you potentially have a tax problem, an estate tax problem. If your estate as a couple is over $12 million, I think you potentially have an estate issue. And that's where planning comes in also, not only with an estate attorney to draw up the documents needed to figure stuff out, but also with an accountant or somebody who can help you with the tax part of that. Okay, next slide, please. Okay, so there's another situation. We talk about gifting to kids, and and we're usually talking gifting low tax base assets. But I've had many situations where a couple has a property. Let's take the property we had before, the $100,000 property that's worth now $1.8 million. But say 4 or 5 years ago, one of the parents passed away. And at that time, I know in one situation, it was valued at $1.4 million. So now we have Prop 19. We have a property that's the income tax base is the 1.4 million because of the step up when the first of them passed away, and you have a property tax assessment very low, 100, 200,000, whatever it is. So there is a situation where you may consider, like, especially if it's a rental property, you may consider gifting to the kids now, because what does that accomplish? You already have most of your income tax base boosted up to the 1.4 million, and you want to retain, if the kids are going to keep that property for any length of time, you want to retain that property tax base. So you have the best of both worlds here. You have a $1.4 million basis for income tax purposes, $100,000, $200,000 basis for property tax purposes. If you gift it now before Prop 19 takes effect, yes, the kid is sitting on a $400,000 capital gain, potentially $100,000 in tax, but it's certainly not $1.6 million in capital gain, which is maybe, $500,000-$600,000 in tax. So it's a better situation. Okay. All right. Okay. So we talked a little bit about this before. How do you handle multiple kids and multiple properties? It's kind of a mess. And if you don't have a huge estate, I don't have a huge estate. I do have some rental properties. I'm planning on doing absolutely nothing. Especially because I have 4 kids and I don't want to start carving up properties and all that. Now, my estate situation can change, and if that's the case, then I'll potentially do some planning, perhaps some LLCs. So we'll get into that next. Okay, so I have plenty of clients that own properties and they put the property in an LLC. Why do they do that? First of all, a lot of their attorneys have advised them that LLCs are good for limited liability. So what happens is if there's a problem with the property in the LLC and somebody sues that person because they sue the LLC because the LLC is the owner, that's as far as they can get. The LLC encapsulates that problem and basically shields the individual owners, the people who would own the LLC from their other assets outside of the LLC being exposed. So that's one reason why people do that. Another reason why people have LLCs, and I think it's going to be very popular in the next couple of years because of Prop 19, is because an LLC allows you to have the best of both worlds with regard to keeping a lower tax base, but getting some level of income tax step up in basis. So it kind of goes like this. And again, you'd have to talk to your professional about this. So let's just say you have an apartment building worth $3 million and you paid $400,000 for it. It's got a very low tax base. Okay, so you got 3 kids. You put the property into an LLC. It's the only asset in the LLC. Then you proceed to gift your children. Let's say you got 3 kids, you gift them 16% each. So now at the end of, oh, by the way, when you put the property into the LLC, that's not a taxable event. For property tax purposes, it's the same owner as it was before, so there's no property tax reassessment. For income tax purposes, all you're doing is changing the entity structure from individual to LLC ownership. So there's no taxable transaction there. If you have a loan on the property, same thing. The lender has to recognize that LLC. They can't call the loan. So now at the end of you put that in the LLC. 6 months later, you do the gift. So now at the end of the year, you have an LLC that owns a piece of property worth $3 million. You're a 52% owner. Your kids are each 16, so that makes it 48, nice and even. And there is still no requirement to report to the county or to the state of California that you have transferred 48% of that LLC to other individuals. Because here's what's happening. You're not transferring a part of the property itself. The property is still the ownership of the LLC. What you're transferring are LLC membership interests. And those are not considered taxable transactions for either income tax purposes or for purposes of reassessment for property tax. So you keep 48% of the low property tax base by doing this. Now, when the person who sets up the LLC, the parent, passes away, the 52% that they own will be reassessed for property tax purposes, no doubt. But also that 52% part will get a step up in basis. And so the kids who remain as the owners, those 3 kids, will get a much higher property tax base, absolutely, on dad's or mom's part of it, but they'll also get a much, much larger capital gain base. So that really helps. Okay, next slide, please. Okay, so the other benefit of the LLC is this. Let's just say that you have you're a single person and you have a $10 million estate. Okay, so and Mr. Biden gets his way and he moves the property, the estate tax exemption from 11 down to 5.8 million. So you are exposed to roughly $4.2 million of estate tax potential, which translates into just under $1.7 million, which is a lot of money. So we just talked just a minute ago about moving a $3 million asset into the LLC and then gifting 48% of it. So let's just say, for our purposes, $300,000 property, roughly 50%. So let's say about $140,000 is roughly going to be the amount of the gift that you're giving. Well, $140,000, $1.4 million, So roughly $1.4 million. So by gifting each kid 1/3 of that, you are eliminating $1.4 million from your estate. But because you're not giving any child 100% interest in that LLC, in the underlying property, you actually get about a 35% discount because of marketability. So instead of using $1.4 billion, you're using only 65% of that. I don't know what the number is, but it's much less. So you're using probably about $1 million of the 1.4. So if you have a $10 million estate and you started to carve it up using these kinds of discounts, you could almost, get your estate down to $6.5 million and therefore almost have no estate tax at all. So the LLCs serve a few purposes. 1, again, they give limited liability. 2, they allow you to gift property to heirs earlier to keep some of the property tax low base. And at the same time, getting some of it in a step up in basis. So you're getting a little bit of both. It's kind of a medium. And then obviously, if your estate is over the estate tax exemption amount, the gifting and discounting of whatever you're gifting helps to reduce your property, your estate tax without using all of your estate tax exemption. And that'll allow you to pass other assets like cash and securities and other than that. Okay, next slide, please. Okay, so possible changes. So again, we talked about Joe Biden coming into office. These are some of the changes that he has proposed. 1, he wants to repeal the step up in basis. That would be a dramatic change to everything we've always planned for step up in basis, for estate planning, for just tax planning. He wants to take away obviously get rid of the larger estate exemption and move it down back to where it was during when Mr. Obama was president. And he also wants to repeal the fact that capital gains get a preferred 20% maximum tax. And again, the reason why capital gain gets the preferred maximum tax of 20% was you're trying to get the economy going over certain administrations. And the way to do that is to get people to invest. In order to have an incentive to invest, capital gains taxes were reduced to a point that's much less than the normal ordinary income tax. So if we get rid of that, I think it's going to have just the opposite effect on investment, and you're going to see things slow down. I think that's it. I hope I've covered a lot of what you needed to know, and I'm sure, Jean, I'll pass it back over to you in case there are any questions.
Well, thank you, Joe. We're actually, we're at 8:10 right now, so we do kind of need to wrap it up. I hope that was helpful for everybody. Thank you for hanging in there, even though we're going a little past time. And I really wanted to put my thank you out there to Jubilee, both Jubilee and Joe. And their contact information is here. We will be sending out a follow-up email to everyone so that you have a link to the video of this session, as well as any specific questions that you have that you can address with them. Again, I would really encourage everybody to make sure that you talk to a professional before you do anything. Just to conclude, I thought this was, I just brought up a few celebrities who actually passed away without a will, and just to kind of bring home the whole message of tonight. These are famous people that I think most of you know, and Tony Hsieh, recently the CEO and founder of Zappos, just passed away, I think a few weeks ago, and it came out that he didn't have a will. All of these people, Jimi Hendrix passed away in the 76, and took about 30 years to actually handle it. Aretha Franklin passed away 2 years ago, and their estate is still, she did not have a will, and so it's still being probated. So it's really, super important. I would end with this quote from Susie Orman, well-known financial planner. She says, "Estate planning is an important and everlasting gift you can give your family." And I think, I hope that with all of this, and I know some of these topics are really complicated, there's a lot to deal with. I think more than anything, the important point, as I was talking with both Joe and Jubilee, is whatever you do, you need to have a plan. There needs to be some planning, there need to be maybe some tough discussions to have with your children, with your loved ones, about all of these things, instead of putting it off. And especially with the year that we've had, and with COVID-19, I think one thing that's really, one point that's really been driven home for me is just the uncertainty of the future, which we've always have with us, but I think it's been even more highlighted this year, that we just don't know what the future will bring. And it's really, having an estate plan in place is something that we do for our loved ones.